Welcome back to City Education, your channel for learning in all forms, shapes, and sizes. Today, we explore a crucial pre-litigation step every aspiring lawyer must master: the letter of demand. Before the court summons and formal litigation begins, this single document could resolve your client's problems efficiently and cost-effectively. What is the letter of demand? I'm sure you're asking yourself the same question. Well, a letter of demand is a formal document sent by the prospective plaintiff to the prospective defendant. It demands payment, performance, or rectification of a breach, and it does so before any formal legal steps begin. Hence, the parties are addressed as prospective plaintiff and prospective defendant. A more rigid definition would sound as follows. A letter of demand is a formal notice demanding satisfaction of a legal obligation, typically written by a lawyer on behalf of a client. Now, why would someone send a letter of demand, or why should they? Well, a letter of demand serves several important purposes. It gives the other party a chance to settle or defend. It might reveal defenses you hadn't considered. It can strategically place the defendant in default, known as mora. It may be required by law, especially when suing a state or in consumer credit matters. Yet again, these are just some and not all the benefits of a letter of demand. Now let's break down the anatomy of a well-drafted letter of demand. It should follow a logical and professional structure. Firstly, we have the sender's details, which are all included in the letterhead. The sender must be the representative and not the client or prospective claimant. Following the letterhead, we'll have the date and references, as well as the delivery method, which is then followed by the prospective defendant's details and addresses. After which we have your Dear Sir, Madam. The Dear Sir or Madam is followed by the heading, which includes the prospective claimant's names and the nature of claim. After which we can begin our letter of demand. The first paragraph is the introductory paragraph, which confirms the authority from the client. We move on to the body, which states the facts and legal grounds of the claim. After which you have your demand clause and your legal conclusion, which will tie the facts to the course of action. The demand clause will clearly request payment or performance. It is very important to include a time frame within the demand clause. After which, we have the sign-off and signature, where the name of the firm or the representative will be placed. This is obviously under yours faithfully. Yet again, different law firms write their letters of demand in their own ways, but the essence and structure is essentially the same. Now, after sending the letter of demand to the prospective defendant, the prospective defendant may reply with a letter of repudiation. The letter of repudiation is similar in structure to the letter of demand. This is essentially a legal response explaining why they deny the liability or why they are proposing a counterclaim. From here, if both the prospective claimant and prospective defendant do not agree, that is where we can begin action in the form of litigation. In court, facts are nothing without evidence. From the outset, lawyers must preserve all admissible and relevant materials, whether it's documents, photos, or witness accounts. These form the backbone of your case and will determine what the court accepts as true. Another thing to note is that some facts are more than just documents. That's where expert witnesses come in. These are specialists like doctors, engineers, or accountants who help the court understand complex issues and give professional opinions based on the evidence. In short, litigation is about proving your case, and evidence as well as expert testimonies are your key tools for doing that. We'll properly dive into litigation in the next few sessions. Now, in conclusion, The letter of demand isn't just a formality. It's a strategic, persuasive, and powerful tool. Whether it results in settlements or signals readiness to litigate, how you draft it can make or break your case. For more content like this, don't forget to like, subscribe, share, and comment. This is City Education, where knowledge finds its voice.